Hey, so if you've ever thought I can save the commission and do this all myself, this video is for you. Today, I'm unpacking a real BC Supreme Court case where almost over $6 million changed hands, a mortgage was called fake, and the court had to sort out who actually owned a West Vancouver property. Spoiler alert, this is exactly why working with a strategic analytical realtor isn't a luxury, it's an insurance policy on your own sanity. Also, a friendly legal note, this video is education, it's not legal advice. Every situation is unique, and if you need legal counsel, I'll loop you into the right lawyer and we'll run point together. I'm Mina Ghani, global real estate advisor and licensed BC realtor, and a professional spot the risk before it explodes person. My job is to essentially protect your downside while getting you the home or the exit that you want. So let me show you how the right foresight could have prevented years of stress in this case. The quick summary in plain English is as follows. So there were two businessmen, they connect. One is in Iran looking to immigrate and invest here in Canada, and the other one is in West Vancouver building a house on Mathers Avenue. They both agree on a $5.58 million purchase. The money starts flowing in 2017 and installments totaling the full price. There's no written contract of purchase and sale. Yes, let me repeat that. There's no formal CPS. A lawyer then registers a mortgage against the property for the full amount, but then later says it was just to protect the buyer's interest from creditors until the title could transfer. So then years pass. The buyer also pays $430,000 towards transfer taxes, but the title never transfers. There's rental income, there are expenses, trust starts to evaporate, and then litigation ensues. So was that $5.58 million a purchase or a loan? The court finds that it was in fact a purchase and the mortgage didn't reflect the true deal, and the current title holder held the property in trust for the buyer. So the order is transfer the property, repay the $430,000 and account for roughly $405,000 in net rent. This wasn't your typical MLS deal. It was a bespoke, high-stakes arrangement with mismatched paper trails. And that's the point. Real estate is law married to money. If you don't align the legal structure with money flow, you invite ambiguity, and ambiguity is so expensive. All right, this is where a realtor with foresight actually changes everything. Insist on a proper contract of purchase and sale, the CPS, up front. Not a handshake, not a send the wire and we'll sort it out. A CPS that's drafted and executed before any money moves, with precise parties, the price, completion dates, representations, and survival clauses, holdbacks, escrows for post-completion items, and just a very clear treatment of rent and expenses if there's a gap before closing. And what happens if the buyer is a foreign national? Then we're going to look at transfer taxes, timing, and alternatives. We need to structure before any wire. So if immigration status or taxes are in play, we set the structure first, look at personal versus corporation, nominee options that are law compliant, and we time to mitigate taxes where possible and legal. And we paper who carries costs and who receives income in the interim. None of this will figure it out later. Title alignment and priority. If an interim security is needed, we're not going to rely on a pretend mortgage. We align the instrument with the intent. An earnest money trust arrangement, maybe a property drafted vendor take back, or an assignment with conditions, or an escrow. All of this so that a court doesn't have to guess what you meant. We want to paper every representation. If there's construction or permits or suites, we're going to reconcile seller's statements with city files, permits, plans, and title. If something is unknown, it's unknown in writing, not as is scribbled on a form, because courts are increasingly treating crossed out or vague forms as very risky signals. And then there's money mapping. So for any rents or expenses during that limbo period, we would set a ledger. Who collects the money, who gets paid, when it's reconciled, and how it credits against the price. So if you ever end up in court, these clean ledgers do the talking. Vibes and interpretations don't. And then we put decision trees together for taxes. Are you a foreign buyer? We'll model the GST, the PTT, the FBTT, and alternatives and timing before you pay $1. The buyer in this case paid $430,000 towards taxes without the title ever transferring. With foresight, those funds sit in escrow with clear triggers, not in limbo. Give the judge nothing to interpret. The best deals are super boring to litigate because they're airtight. My personal test, if a stranger reads our documents with no backstory, would they land on the same meaning? If not, we'll keep drafting until they do. Okay, so you're probably thinking, yeah, but that means I have to pay a realtor commission. Yes, commission is a cost, but delay, double payments, disputed rents, extra legal fees, and years of limbo are actually a greater cost. So in the Mathers Avenue case, this delta wasn't a few basis points. It was years and hundreds of thousands in side effects. A sharp realtor's job is to do front load clarity so that you don't backload litigation. So from a buyer's standpoint, what I would do is lock in a CPS with protective clauses and realistic timelines. City file permits, title, and reconcile the paperwork with reality. If immigration and taxes matter in this case, build the structure, escrow, and triggers first. Document all the rent and expense ledgers for any interim occupancy and keep a decision log. If anything changes, we amend that on paper. From a seller's standpoint, I would ensure that your representations are accurate or explicitly state that you do not know. You want to align your intent with your instruments. None of this crossed out forms, no pretend securities. If you keep property on the market versus taking it off after receiving funds, there better be documentation as to why, for how long, and what happens next. Protect you from post-closing claims with clean disclosures and scoped data rooms. So what's the big lesson in all of this? The court ultimately recognized that the buyer's beneficial ownership existed, and then they ordered the title transferred and the rental income to be accounted for. But getting there took years. A strategic realtor would have anticipated these pressure points, the title, taxes, timing, rent, and solved them on day one. That's the difference between saving commission and protecting millions and your sanity. If you're a high achieving buyer or seller who wants that clarity, protection, and leverage, let's talk. I build the deals that close cleanly and hold up if tested. Book a complimentary consult at minagani.ca and we can discuss my due diligence checklist that will keep you protected. And again, a friendly reminder, this video is educational only. It's not legal advice. Every situation is unique. And if you need legal counsel, I'll loop you in with the right lawyer. And like I said, we'll run point together.